These hearings, of course, have moral, political, and legal ramifications. For a closer look at the latter, Kan Nawaday, former federal prosecutor of the Southern District of New York, joins us now. Kan, today the committee really focused on former President Trump, his supporters, and the potential ties, directly or otherwise, that they had with these extremist groups that then stormed the Capitol. The president, it's been established with evidence now, knew that many of these protesters were armed going into the Capitol. What kind of criminal liability could Trump face?
The same type of criminal liability that the insurrectionists are facing. Frankly, he can be charged potentially with seditious conspiracy. He can be charged with obstructing the proceedings that were occurring that day to certify the electors. I think that evidence that Trump knew that weapons were there, that he believed and said, they're not here to hurt me, begs the question, well, who are they here to hurt? And then he took that further step of telling everybody who he knew was armed, hey, let's go up to the Capitol, I'll meet you up there. And that is devastating evidence. And I think that is evidence that's probative of an act in furtherance of a conspiracy.
And today we heard Representative Liz Cheney say that former President Trump cannot escape responsibility as it pertains to the law. Let's take a listen.
No rational or sane man in his position could disregard that information and reach the opposite conclusion. And Donald Trump cannot escape responsibility by being willfully blind. Nor can any argument of any kind excuse President Trump's behavior during the violent attack on January 6th.
And I want to focus in particular on that willfully blind. How can this committee at this point prove criminal intent?
And I'm glad you point that out, Linsey, because Liz Cheney, Congresswoman Cheney, is actually talking in criminal law terms when she says Trump can't be willfully blind to what had happened in his responsibility. Because there is a concept in criminal law that if you don't have actual knowledge of facts that lead to criminal intent, prosecutors can prove that you actually have knowledge because you consciously avoided those facts. You were willfully blind. And that is one way prosecutors can prove criminal intent here, although it's quite difficult. I'll say this, that if all a prosecutor has to prove intent and knowledge is willful blindness and conscious avoidance, that's a tough case. What you want is actual knowledge. And that's why I spoke a little bit about what Trump said during the ellipse speech when he said, hey, let's go up to the Capitol, when he knew that there were guns and armed, potentially insurrectionists who he was sending up to the Capitol. So that's actually actual knowledge.
And Representative Cheney also talked today about knowledge that the former President Trump had called a witness who had not yet testified publicly. She said also that that witness did not answer the phone. But how much does that up the ante potentially for criminal conduct in this case?
That in and of itself could potentially be a separate crime of obstructing justice or witness tampering, especially if, as alleged by Congresswoman Cheney, that it was Trump who made that phone call. The difficulty there is the phone call was never taken. So we don't know what would have been said with that conduct and with that contact.
Kan Nawaday, we thank you so much as always. Appreciate your time.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.